Well, welcome back from break. Was it refreshing? Yes? Paparazzi. It is my pleasure to introduce our fourth general session entitled the Multi-Ethnic Placement Act as Amended. And we are so excited to have this presentation. I know that a lot of states have been asking for information on Mepa, so it's just great that we have the national experts with us here today to discuss this very important topic. And this session is actually being presented by two individuals, one of which you might remember from the large screen production or webcast, Title IV-E Adoption Assistance, everything you always wanted to know but were afraid to ask. And if you missed this groundbreaking Oscar-winning performance, you can still catch it on our webcast, our NRC website at www.nrcadoption.org. So let me formally introduce our speakers. The first is Kathleen McHugh, who's the director of the Policy Division of the Children's Bureau. This division provides leadership and direction in policy development and interpretation for the Title IV-E foster care and adoption assistance programs and the Title IV-B programs of the Social Security Act, plus the Child Abuse Prevention and Treatment Act. The division is also responsible for writing regulations, interpreting national child wealth policy through the Child Wealth Policy Manual, and working on federal legislation. Ms. McHugh has served at the Children's Bureau for 15 years. She has worked in child welfare nearly all of her career, including work at the local level in child protective services, foster care, independent living, and adoption. And we also have with us Eileen Hanrahan, who I have to say is a graduate of the University of Michigan Law School, go Blue. But not more importantly, but she's also, now those of you all who know me, I have to give the shout out for Michigan grads. It's very important. She's also the Supervisory Civil Rights Analyst in the HHS Office for Civil Rights Division, where she serves as Section Chief and Senior Policy Advisor on issues related to OCR's civil rights jurisdiction and the enforcement of Section 504 of the Rehabilitation Act, the Americans with Disabilities Act, and the Age Discrimination Act. Eileen also provides expert policy advice on compliance and enforcement strategies for the Multi-Ethnic Placement Act and Title VI of the Civil Rights Act to ensure that adoptions and foster care placements occur without discrimination due to race, color, or national origin to support children finding parents best able to meet their needs without delay. Prior to joining HHS, Eileen spent 15 years as a staff attorney in the Department of Education's Office for Civil Rights, where she focused on discrimination issues concerning students with disabilities, limited English proficiency, minorities in special education and educational testing, and 2 years with the U.S. Commission on Civil Rights, focusing on disability discrimination issues. So please help me give a warm welcome to our Mepa panel today. We're so very excited that they're here.
Hello, everybody. Good morning. I'm Kathy McHugh, and I'm going to start today. I am with the Children's Bureau. Let me tell you, this is the first time I'm using this kind of quote technology, so I hope that I'm doing it right. All right, so, okay. Title of the presentation, Ensuring the Best Interests of Children Through Compliance with the Multi-Ethnic Placement Act of 1994 as amended, and Title VI of the Civil Rights Act of 1964. Let me just say a few words that this presentation was developed jointly by the Children's Bureau and the Office for Civil Rights. Many long hours have gone into this, and as you can imagine, I know Eileen and many other folks have worked on many hours on it. So we are hoping that this presentation today, though, will be the beginning of our Mepa training plans. We are planning for some upcoming opportunities for additional training, as well as opportunities for questions. And with regard to questions today, as you can imagine, it's very tricky when you're answering questions about Mepa. You know, it does involve the Office for Civil Rights as well as approval by the Children's Bureau. We will try to answer questions to the extent that we can, if they're related to the presentation. If there are new questions or things that we're not feeling like we really can get into, this is a tape presentation, I understand. We will be able to take the questions and answer them in the future through one of the avenues of the NRC. We're starting out with some statistical information here for you. I'm sure this information is not new. There are approximately right now, well, as of January of this year, over 500,000 children in foster care. 129,000 of those are waiting or were waiting to be adopted at that time. And on the average, children wait 39.4 months to be adopted. So this certainly does address or give you a sense of some of the challenges that the child welfare workforce is faced with. So to address some of these factors, we had Mepa in 1994. Congress passed the Multi-Ethnic Placement Act with several purposes of that law. Those are identified on the screen to decrease the length of time the children wait for adoption, facilitate identification and recruitment of families, and to prevent discrimination on the basis of race, color, national origin. We've got two slides coming up, slides 5 and 6, that talk a little bit about the historical perspective of Mepa, which I'm sure many of you are familiar with. You've been around, particularly working in the program, especially I'm sure you're aware that Mepa supplemented existing legal standards prohibiting discrimination on the basis of race, color, national origin. These are the Equal Protection Clause of the 14th Amendment to the United States Constitution and Title VI of the Civil Rights Act of 1964. And as you are familiar, Mepa does contain two central provisions prohibiting the use of a child or prospective parent's race, color, or national origin to delay or deny the child's placement. Additionally, it requires states to provide for diligent recruitment of potential foster and adoptive families that reflect the race and ethnicity of the children in care who need homes. Okay, a little bit more historical information on Mepa. It was amended in 1996 to affirm and strengthen prohibitions against discrimination by removing potentially misleading language that was in the law regarding the consideration of race, color, and national origin. And it strengthened compliance and enforcement, including penalties for state agencies and entities that violate Mepa. What we are seeing that implementation is varied. Times there's misinterpretation and confusion about the law. There could actually be avoidance of any consideration of race, color, national origin for fear of violating the law. And at times there's outright violation by considering race, color, and national origin inappropriately. Okay, so today what we're hoping is that we can learn a little bit about when race, color, national origin may not be considered, may actually be considered, and when it must be considered. Okay, so now the agenda. Slide, I guess, 9, right? Okay, we're on slide 9. The agenda is basically 6 or so topics, federal laws, practical guidance, the roles of the offices involved in the Mepa violations, enforcement, and some compliance tips and resource information. Okay, so Eileen's going to be beginning now with the law.
We apologize, excuse me, for the tag team here. This is to help you all stay awake because we have 60-something slides to get through. So good morning, everyone. I'm glad to be here. I also am not very good at technology, but we'll see how it goes. We're going to be getting more into the substance of Title VI and Mepa now. So before we do, just a couple of cautions. One, that we'll be providing some examples of violations of the laws. We just don't want folks to think that they represent an exhaustive list of the potential violations. And second, that certainly the consideration of race, color, national origin issues come up most frequently in looking at trans, what we call RCNO for short, placements, but the principles and standards that we'll be talking about apply to any consideration of race, color, national origin, whether in trans RCNO placements or same RCNO placements. So we're going to be talking about these 3 laws today. Title VI of the Civil Rights Act of 1964, which my office, OCR, enforces. the diligent recruitment of prospective parents, provision in Mepa, and then provisions in Mepa that apply to the consideration of race, color, or national origin in placements. So who do these laws apply to? Title VI applies to any entity that receives any federal funding. So many agencies actually enforce Title VI. It would apply to any state or county child welfare agency as well as any private agency that does receive federal funds. MEPA applies, of course, to any state child welfare agency as well as any other entity that receives the Title IV-E or IV-B funds, including contractors. The state, as you know, is subject to the diligent recruitment provision, and MEPA included a provision when it was amended to make clear that a violation of MEPA is considered a violation of Title VI as well. So what do we mean by race, color, national origin? Race is pretty straightforward. It could be black or African American, white or Caucasian, Asian or Native American. Generally use the groups that the Office of Management and Budget uses. Color means pretty much what it says. It's the color of somebody's skin. National origin really has to do with either a child's or a parent's ancestry or ancestral background. So it could include, for example, German, it could include Australian, Chinese, Peruvian, Italian, it includes Hispanic. So under Title VI, when we talk about discrimination on the basis of national origin, that includes discrimination on the basis of Hispanic ethnicity. Now, finally, we know that Title VI and MEPA do not cover discrimination on other bases, such as gender, disability, age, or culture. But while culture is not covered and HHS does not define culture, if culture is being used as a proxy or a substitute for race, color, national origin, it would be treated under the law the same as a classification based on race, color, or national origin. So Title VI has lots of provisions in it, including lots of general provisions. The basic bottom line is that covered entities cannot treat another individual differently on the basis of race, color, national origin. How that treatment takes place can be in several different ways, so some of them are listed, but the fundamental principle is that individuals can't be treated differently on the basis of race, color, or national origin. Now, under Title VI, which dates back to 1964, so it preceded MEPA by a good many years, any consideration of race, color, or national origin by any entity that receives federal financial assistance must meet a strict scrutiny test. What that test means across the board for any entity that is covered by Title VI is that consideration of race, color, national origin is permitted only if it's narrowly tailored or necessary, in other words, to achieve a compelling interest. There are compelling interests that may apply in other contexts. For example, I worked in education and diversity was considered a compelling interest in that context. In the child welfare context, the only interest that the law recognizes is advancing the best interests of the children. Finally, race, color, national origin can only be considered on an individualized basis, and we'll talk a little bit more about what that means. This is your sort of basic principle for Title VI, looking at consideration of race, color, national origin, and placements. So this is really all of it in a nutshell. Again, consideration is permitted so long as based on an individualized determination, the agency has concluded that consideration of race is required or necessary to advance this particular child's best interest. And I'm going to pass the mic and remote back to Kat.
Okay, I'm going to talk a little bit more about Title IV-B and IV-E of the Social Security Act, which I'm sure you are all familiar. As you know, Title IV-B addresses the foster parent recruitment provisions, and Title IV-E addresses race, color, and national origin in the child's placement process. And up on the screen is the Title IV-B state plan requirement for diligent recruitment. And as you know, as part of the plan for IV-B, states are providing for diligent recruitment of families who reflect the race and ethnicity of children in care. Under IV-E, we've got the MEPA state plan requirement. And as it says up there, a state or another entity that's involved in adoption or foster care placements may not deny an individual an opportunity, and also receives 4E funds from the government, may not deny an individual the opportunity to foster or adopt on the basis of the child or the family's RCNO, or delay or deny the child's placement into foster care or adoption on the basis, again, of the child or the family's race, color, and national origin. So that's the 4B and 4E. These are the topics that will be coming up in the next few slides that will be addressing the practice considerations. And we're going to go ahead and start with diligent recruitment. So, as you can see up on the slide, the diligent recruitment is addressed on 22, where it's also going to be addressed on slides 23 and 24. This slide speaks to what the states may do. So the state may conduct activities to recruit parents who reflect race and ethnicity of the children who need homes in the state. The state also may develop its own recruitment plan or utilize private agencies that specialize in understanding communities and identifying families of specific groups of children. And the last bullet we wanted to note is that the diligent recruitment provision does not require an agency to recruit families for the purpose of increasing the number of transracial placements. Okay, slide 23 addresses what states must do in conducting diligent recruitment activities. The state must allow prospective families to participate in general recruitment irrespective of the race, color, and national origin. They also must accept applications from potential parents who are not from one of the communities where the agency is focusing its activities and include them in general recruitment. So what we're saying here is the agency has to accept those applications from any family. And they must accept applications from prospective parents who express interest in providing care for children whose race and ethnicity does not match their own. So those are some of the basics. Some components of a diligent recruitment plan may include the description of the characteristics of the children for whom the foster adoptive homes are needed in the state. It could also include some specific strategies to reach individuals and communities that reflect the children in care who need homes, including some diverse methods for disseminating general and child-specific information, strategies for ensuring that all families have access to home studies, and strategies for training staff to work with diverse communities. That finishes up diligent recruitment, and slides 25 and 26 are going to be dealing with denial of opportunity. So as indicated here on slide 25, it's identifying some specific behaviors that would lead to denying someone an opportunity to foster or adopt based on race, color, or national origin. So that if there is an appropriate placement for a child, an agency may not refuse to place a child with a prospective family because the parent's race, color, and national origin is different from the child's. The agency may not fail to place a child with a prospective family because the parent or the child is a specific race, color, national origin, and the state may not remove a child from a prospective parent or any parent because the parent or child is a specific race, color, national origin, and the state may not refuse to conduct a home study because the parent or child is a specific RCNO. I think those are some basics. This slide is entitled Delay or Denial of Placement, and here we're contemplating a circumstance where the child, like most children, will be able to be placed without consideration of race, color, or national origin. So, These are some specifics. If an agency has determined that an appropriate placement for a child exists, the agency may not allow the child to remain in shelter or another temporary type of placement or require any type of holding period to find a particular race, color, national origin placement, foster or adoptive placement, because that would be an impermissible delay. The agency also may not remove a child who's doing well in a pre-adoptive placement in order to place the child with a family of a particular race, color, or national origin. Of course, that would be impermissible denial. And last, the agency may not switch a child from one foster placement or adoptive to another in order to place the child into a particular RCNO placement. And the last sentence we wanted to note specifically, even if the agency later reversed itself, that really would still be considered a delay, an impermissible delay and denial. That basically wouldn't correct the situation. So I'm going to hand it over to Eileen now for individualized assessments.
An individualized assessment, as we know, is one of the requirements for consideration of race, color, national origin under Title VI and MEPA. So while an agency has the discretion and the flexibility to consider whatever factors it wants in evaluating a child, obviously the consideration needs to be in compliance with any applicable laws, and those laws include MEPA and Title VI. So if a social worker or an agency believes that it may be necessary to consider race, color, national origin for a particular child, the agency must conduct an individualized assessment for that child to make a determination. And it has to be based on the particular circumstances, the unique or the specific factors that apply to that particular child. So an agency cannot rely on generalizations or assumptions about what a child needs based simply on the child's membership in a particular race, color, or national origin group. And as a corollary to that, it means that the agency cannot routinely or as a matter of course consider race, color, or national origin in assessing a child. It really needs to be something that is triggered by this child's unique background or history or presentation of circumstances. So what factors might trigger the idea that race, color, national origin perhaps should be considered for this particular child? One example is if a child has had a traumatic experience, such as having been in an environment that was abusive and that is linked to race, color, or national origin for that particular child. You may want to consider placing the child in a different environment, a different race, color, national origin environment for that child's health and safety and appropriate growth. There also could be other factors that the social worker, on reviewing the particular child's file and based on their understanding of the child and the child's background, may decide, present an opportunity or an occasion for considering race, color, national origin. Now, some states, as you know, have policies that state that at a certain age a child must consent to being adopted. So if your state has such a law and you have a child that meets the age of consent, the agency can honor the child's request or refusal for a certain placement based on race, color, or national origin without violating Title VI or MEPA. It would be good practice in those circumstances in any event, and we're going to be talking about documentation later and what are good practices. It would be a good practice here to just make a record of the agency's determination that given the child's age and the child's preference, it is in the best interest of the child to take into account the preference. If your state does not have such a law, or if the child that is being reviewed and considered is not of that age, then the preference of the child cannot dictate the placement. It would be appropriate in those circumstances for the social worker to look more deeply, to delve more closely into the child's preference, as well as all of the other circumstances that apply to that child, and make its own determination of whether it should consider race, color, or national origin in the placement. Now, some folks, agencies like to use outside professionals in making an individualized determination. It's not required, but if an agency wants to do that, it's certainly permissible. It's also permissible to use their own staff. In general, it's conceived that in most cases, a child's best interests can be advanced without consideration of race, color, national origin. So under the law, it would generally be considered a rare case where consideration is appropriate. So as sort of a guiding principle, this conveys that it's a somewhat high standard. So if an agency has determined in a particular case that it is appropriate to consider race, color, national origin for this child, it's not really a carte blanche or blank check to consider it in any way. The consideration needs still to be to the extent necessary to advance the best interests of that particular child. So now, while an agency, as we said, has the discretion and the flexibility to choose the factors to evaluate the child, it has the flexibility and discretion to how to weigh those factors, but in doing so, it cannot let the factor of race, color, national origin predominate, and here's another unless, based on its individualized determination, it has determined that race, color, national origin is a more important factor, needs to be weighed more highly. Now, if an agency has identified 2 or more appropriate placements, it cannot use race, color, national origin to distinguish between the placements, but can use other factors that may be characteristic of those families in order to decide which is the more appropriate placement that the child will receive. And I think we are up to Kathy again.
So, the next 4 slides are titled Culture and Cultural Competence. And so, starting with slide 34, we want to first note that MEPA and Title VI do not address the consideration of culture in placement decisions, and HHS does not define culture. So, having said that, an agency may not use culture to replace or serve as a proxy, as we talked a little earlier, for routinely considering race, color, or national origin, which is prohibited. But in Bullet 3, some acceptable non-discriminatory cultural issues to discuss with a family are identified, and they could include holidays, the ability to communicate, religion, or food. An agency may not assess a family's or a parent's ability to parent a child of a particular race, color, and national origin through the use of a cultural competence test. And further, an agency should be cautious when assessing or considering a family or a child's culture on a home study form or elsewhere. An agency may not assess or ask prospective parents to assess whether they are competent to parent a child whose race, color, national origin differs from that of the parent. Throughout a family's interaction with the agency, furthermore, an agency may not ask or consider the following: why a family wants to parent across RCNO lines, what a family knows about the RCNO that's different from its own, and last, whether a family's activities reflect a knowledge or an appreciation for the race, color, national origin of the child that the family wishes to parent. And the last slide on cultural competence states that an agency may not require prospective parents to take different or extra steps in order to parent a child who is in foster care or being adopted on the basis of the parent or the child's race, color, or national origin. Furthermore, the agency may not single out parents who want to parent across race, color, national origin lines, or require them to learn about the different race, color, national origin. And last, the agency may provide, however, information to parents that will help them care for the child, including information about personal care issues. Okay, the next slides will be focusing on assessing and preparing prospective adoptive and foster parents. Starting with slide 38, The agency may not have a different process for parents who wish to foster or adopt a child of a different race, color, or national origin. For example, there are 3 bullets of types of things we would like to point out to you that would be problematic. A longer or more invasive home study process, requests that are specific to families who plan to parent across race, color, national origin lines. For example, a transracial or a RCNO parenting plan. And last, requests that a parent learn about a different race, color, or national origin in advance of parenting such a child. For example, we're pointing out some things like requiring the family to purchase or review specific materials or interacting with individuals of the particular race, color, or national origin. Preparing prospective families. An agency may offer training to prospective parents about parenting a child of a different race, color, or national origin if the following. It's offered to all parents, regardless of whether the parents plan to foster or adopt a child of a different race, color, or national origin. And the participation in the training is not a precondition for parents who intend to pursue a trans racial, cultural, national origin placement. So it's not a precondition. Continuing with parenting, preparing parents, the agency may offer trans, racial, color, national origin parenting information to families who request it, and that is bolded. But a few things that the agency has to ensure: that the information is consistent with Mepa and Title VI, that the information is provided regardless of the child or the parent's race, color, or national origin, and that the parent is not pressured to receive such information even if the parent expresses an interest in parenting across racial, cultural, national origin lines. And last but not least, it is not used as an assessment or a home study tool. But let me go ahead then and note that an agency may offer the transracial, color, national origin parenting information at its own discretion, as long as the following. First, the information is made available in the context of preparing a parent and not assessing the parent's capacity to parent the child. So that's key. That consideration of the information or participation in related services is not a precondition for parents of a certain race, color, or national origin, or who want to pursue a transracial national origin adoption. So in other words, it is not a precondition. In such instances, an agency may prepare a family to foster or adopt a child of a different race, color, or national origin by asking the parent to describe their questions or concerns, connecting families with helpful resources, and offering post-placement services such as support groups and the like. Okay, slide 42 addresses some allowable practices in preparing prospective parents. So the agency may tell the parents whether the child or children in care do or do not have the characteristics that the parents are seeking. For example, the age, the special needs status, the race, color, national origin of the available children. The agency may ask the prospective parents whether they will consider providing a home for a child whose characteristics reflect the children for whom the homes are needed. And an agency may discuss with the parents the challenges that may arise when parenting a child whose characteristics differ from the characteristics of a child that the parents originally sought to adopt or foster. However, an agency may not discourage parents from pursuing a trans RCNO placement or require parents to participate in any training related to RCNO unless such training is also required of all parents. Okay, the next 2 slides are covering the topic of parental requests. And Slide 44. Prospective parents may not make requests, may make requests about any characteristics of a child that they would like to adopt or foster, including race, color, and national origin. However, agencies are not required to place a child of a particular race, color, and national origin with a parent who has indicated that the parent does not want to parent a child of that particular RCNO. But agencies must be as flexible with parents' requests related to the race, color, and national origin of a child as the agency is with the parents' requests related to other types of characteristics of a child, and be similarly flexible with presenting those children to the families. For both voluntary and involuntary removals, agencies may not consider or honor the request of parents or legal guardians to place the child with a foster adoptive parent of a specific RCNO, and this does apply to birth parents who are considering placing their infants for adoption as well. Okay, we've got two slides titled Concerns about Prospective Parents. So let me go over those now. Mepa and Title VI do not require an agency to make a placement where a prospective parent's comments or beliefs make it clear that placing children of a specific race, color, or national origin with their family is not in the best interest of those children. So where a family expresses prejudice about people of a certain race, color, or national origin, but still wishes to adopt or foster a child of that RCNO, a few things in the bullets should take place. The agency should delve further into the issues. If the agency believes that the parent should not parent any children of a certain race, color, or national origin, then the agency really must or should document the reasons for that belief or for its resulting placement decision. In other words, document your reasons for your belief that this parent is not suitable. And a decision that is necessary to achieve the child's best interest, including a decision to not place a child of a certain race, color, national origin with a family, does not violate MEPA or Title VI. Okay, this next slide we wanted to address the Child and Family Service reviews. As you know, they do address or assess whether a state is maintaining a child's connections to his community and his family and his neighborhood. And in many cases, this certainly is a good idea, particularly when you're talking about reunification. So making these concerted efforts to maintain a child's important connections does not violate MEPA or Title VI. And we wanted to talk just a little bit about photo listings here in this slide. An agency may identify or document the race, color, or national origin of a child who's featured on an adoption website, such as an Adopt US Kids. The agency may design and administer adoption listing websites that allow the families to search for a particular child based on the child's race, color, or national origin. And the agency must treat the race, color, or national origin in the same manner it treats the other characteristics of the child, including his or her age, gender, membership in a sibling group, that sort of thing, if an agency identifies a child's race, color, and national origin on its website. So basically, you've got to treat it in the same manner. And Eileen is going to take over now. Thank you.
This is the part of the presentation that's basically titled, We're from the Federal Government and We're Here to Help. So I'm going to talk about, OCR and ACF coordinate quite a bit at the regional level as well as at the headquarters level. We have overlapping jurisdictions, even though we have other roles and responsibilities that really are very different. OCR, as I mentioned, enforces Title VI and the civil rights provisions of Mepa. And again, Title VI would apply to any entity that receives any federal funding. So it would include state child welfare agencies, any counties, and any private agencies that may receive federal funding. OCR makes determinations of compliance or non-compliance in investigations. Basically, we enforce the laws in three ways. One is through complaint investigations. The second is through compliance reviews, which are really agency-initiated investigations where the agency has a concern that there may be non-compliance. And third is through the provision of technical assistance. So in all of these measures, really the focus is on voluntary compliance. In fact, under the regulation, we're required to seek voluntary compliance until it can't be secured. In the event we can't gain voluntary compliance, we do have the authority to take steps to terminate federal funding as well as to refer a case to the Department of Justice. Now, ACF administers, as you know, the Titles 4B and 4E parts of the Social Security Act. It ensures that the states meet their state plan requirements, and if a state fails to do so, ACF has authority to assess a penalty. ACF also, like OCR, provides technical assistance to help states make sure that their child welfare programs are in compliance with the law. So we can become involved in working together in different ways, either through cases, including private litigation, and the Child and Family Services reviews, or sometimes on policy or coordination and training, like this PowerPoint, which we work very closely on, even though ACF gets the credit for doing most of the work. So what happens when we receive a complaint investigation, OCR will share the allegations with ACF, and we generally will coordinate and share information during the course of an investigation. If we are finding non-compliance or compliance, we generally will share the LOF with ACF. ACF can look through our investigative file, can review the LOF, and determine if it sees any violations of state plan requirements or any other violations of the Mepa regulation or Mepa policy. So basically two kinds of violations. Individual violation is where we've identified a particular child or parent that may have been discriminated against. And a systemic violation is really a broader violation where groups of folks may be affected, and that can include a law or policy or a practice or a procedure. These are some examples of cases, actual cases that OCR has had in which it has found non-compliance for these different types of issues, and I won't read through all of them, but there is information on the OCR webpage where you can look at the letter of findings as well as the agreement that was reached in the case, and as you can see, it's a pretty wide range of issues, and a number of the agencies involving some of these violations are still in monitoring. If we do find that a state has violated Title VI or Mepa, we generally will enter into what's called a CARP, or Corrective Action and Resolution Plan, and that will set forth various steps that the recipient needs to take to come into compliance. If ACF finds that a state has violated its state plan requirements, it will assess a penalty against those various state funds. In addition, if a private agency has violated the law, it's required to return the Title IV-E funds that it received during the quarter of the year when it received notice about the violation. If we find that a state has had a policy, practice, law, or procedure that was in violation, in addition to correcting the non-compliant practice or procedure, whatever it may be, there are other elements of the CARP that are pretty common across different agreements. Those include training for staff, generally notice of prospective or past parent applicants about the violation, also require periodic data submissions as well as a schedule of compliance reports that need to be submitted to the agency. And some of these plans can extend from a very short period of time, like 6 months, to a few years, depending upon the extent of the violation. If a state would like, it can appeal OCR's finding within the department. If it still would like to go beyond that and is unhappy with the department's decision, it has authority to seek additional review in federal district court. Now, some states have delegated their state plan responsibilities to county-administered systems, In that event, under Title 4E, the state is still responsible for ensuring compliance and for correcting the violations. Under Title VI, in addition to the state having responsibility, the county itself as a recipient is also directly responsible, and an OCR would include provisions applicable to the county as well. So the state is eventually, ultimately held responsible for ensuring the compliance of the counties. Oops, I think I went too far. Oh, yes, okay. And now we're up to compliance tips. And Kathy, you're.
Okay, so we've got a few slides entitled Compliance Tips. And as you can see, document, document, document. You'll be seeing that in the next few slides. And so just to start off then with this slide, 62, ACF and OCR will examine the facts of each case where a MEPA Title VI violation may have occurred. So because each case is determined based on the specific facts and circumstances of the allegation, ACF and OCR can't provide a specific list of documents that will insulate the state against a finding of Title VI or MEPA, but if the agency decides to consider race, color, national origin when making a placement decision, the agency really should consider creating very strong documentation. The record of documentation should relate to some of the following. Who is involved in making the decision to consider the race, color, national origin, including the supervisors, the agency process for deciding to consider RCNO, whether outside professionals were involved, whether an individualized assessment was done, whether the agency advised the outside professional, if they used one, that the law prohibits routine considerations of RCNO, whether the outside professional interviewed the child and reviewed the case file. The agency also would want to document the results of any individualized assessment, any rationales for conclusions and recommendations. Of course, how the decision to consider RCNO is narrowly tailored to advance the child's best interests would need to be addressed, and any documents that reflect the details of the selection or placement committee's decision, who was present, etc., would be important. Okay, continuing with document, document, document. When the agency declines to place a child with prospective parents and the reason relates to the race, color, and national origin, the agency really needs to describe in the case file as much detail as possible for the reasons why that parent was an unsuitable placement option for the child. Some agency actions, compliance tips for agencies. Agencies really should develop a peer review process or consider one in considering placement options. The other consideration would be to develop a supervisory chain of command process to review decision making. Other considerations and actions to consider would be, of course, training, not only your agency staff, but your contractors, your new employees. Perhaps refresher courses would be in order. You'd want to be sure all of the entities that you contract with in particular know how to apply MEPA and Title VI to the day-to-day practice. So we've identified some resources and technical assistance. Of course, we've got the ACF and OCR regional offices. You, in particular, would want to consider asking those folks to review proposed training materials or curriculum before using it to be sure that it does comply with the law. There's also, of course, the websites that you'd want to keep track of what's going on. I know that there are new additions from time to time. And of course, we do want to provide the ability to partner with you to be sure your system, the child welfare agency system, is fair, free from discrimination. So we are here to help. And in particular, the last slide does mention some specific legal citations that you might find handy all in one sheet, including our Child Welfare Policy Manual, and further specific legal citations. So that concludes it. I do hope that you will take this back to your states, look it over, think of the questions, gather your questions, and start to send them in to us. Thank you.
Are there any questions? Yes.
Is your PowerPoint available that we could put on the NRC website so that people could make use of it? Great.
She said that it will be posted. There may be some amendments, but that it will be posted when it's corrected on the website, the NRC for Adoption website. Other questions? Could you go to a mic?
Okay. I have a couple of questions and I mean, I think you guys have done, in general, I think you've done a great job of trying to define this. But I have a couple of concerns. Number one, as we all know, with the overrepresentation of African American and Native American children and children of color in the system, you know, Mepa behooves us to take a closer look at what has happened in the last 10 to 15 years since we had ASFA. I think what I've gotten from this and from your presentation is a sense that the interpretations that you have here are more or less promoting a colored blindness or RCNO blindness approach to addressing the issues of race and culture in child welfare, and maybe on some level that's a good thing, but the reality is that the children in the system, they have a sense of what color they are. You know, they know what color they are. The families know what color they are. And in our field, in the field of social work, I think it behooves us to be willing to address race, class, and culture, because it impacts everything we do. It impacts the lives of the children. It impacts the workers in our system. It impacts the families. I do like that your approach seems to be, which is good for me to hear, is that you're guiding us to making the distinction between assessing a prospective parent and preparing a prospective parent. So I think that's, you know, out of everything I've heard, I think that's the key difference that I think states can take back to their states and their counties to figure out how to address MEPA and how to do this work. But I really am fearful of an interpretation that seems to focus on colored blindness and RCO blindness. I think that's wrong, because race is a reality in this country. Race is the elephant in the living rooms of the families that we work with, in the workrooms and in the cubes where we work, and in the society in general in this country. And so, you know, I would also encourage you in your interpretation and the guidance that you give to states to be a little more descriptive in how we can address those issues for the families. And the families, I live in Minnesota, and the white families that we work with, they know they're adopting or considering and being foster parents to children of color and to black children and Native children. And you know what? They ask us, help me do this work. Help me parent a black child. Help me be a foster parent to a Native child. They want that. They want the culture. They want the race. They want the faith. They want the differences. And they want us to tell that to them. And that is important in our work. I'll give you an example of that happened recently. I work with disparities in the state of Minnesota. I supervise Indian child welfare African American disparities, foster care, Title IV-B, Title IV-E, and a lot of stuff. But I was doing a case consultation in one of our counties, and the workers, and this is an extremely white county in Minnesota, and I was doing a case consultation on disparities and working with African American families, and the worker told me about some of the problems that they were having. They were doing a supervised visit of an African American mother who was working with her children, who was visiting her children, and they noticed that during the process, the black mother sat there the whole time and combed her daughter's hair. And she said that and the mother did not interact with the other kids who were in the room. So she said that they reported in their case file that the mother was unresponsive to the other children. I said, well, gee, that's a problem, because you know what? Within the African American community, our code of conduct says that hair and appearance is important. So what you consider to be a deficit is a strength in our community, that the mother focused on combing her child's hair. You know, it's these kind of cultural differences that workers don't know, that foster parents don't know, and they talked about how the foster parents in their county, you know, they don't do the black children's hair that are in their care. They don't do the kids' hair. I said, but hair is important. If a African American mother goes to visit her African American child and sees that her child's hair has not been combed, regardless of what that foster parent is saying about how much I love your child is great, you're bright, within her community and within her cultural context, she said, no, you don't care about my child because you didn't even care enough to comb her hair. You know, these are the things, the idiosyncrasies of race and class and culture in this country, and we do need to address them. And so that's why I'm saying your interpretation and how you train us and how you support us in doing this work needs to take stronger consideration of class and culture in this society. It does make a difference, and it makes a difference in our work. Thank you.
I know we can take this back with us as well, but just a couple of thoughts, and thank you. I'm sure a lot of folks are thinking some of what you're saying, and there's certainly different perspectives on the law. I don't know that I would necessarily characterize it as race, color, national origin blind. It might appear to be that way from the training, but I think the training is really trying to get folks to focus more on something uniquely associated with a particular child, so that people aren't necessarily approaching things with those kinds of generalizations and assumptions that maybe that maybe have their place, but legally we want a system to ultimately be free of discrimination. And I understand what you're saying about the class and the race and the ethnic and economic issues. I think we need to kind of work within the framework of the law and hope that as we sort of advance and become more knowledgeable about different segments of our society, that we'll do a better job of that. I know that the law does allow, if parents have requests for certain types of information, certainly the social workers can give them that information. If a social work agency wants to include information or provide training about caring for kids of different racial or ethnic groups, that's permissible if it's provided for everybody. So there are some, I think, opportunities that the law recognizes to try to move adoptions and foster care to a better place for every child. It's not a perfect system, but I think ultimately the goal of the law is to try to reach the point where we're not discriminating for any reason. And the law, as it's drafted under Title VI, excuse me, has a certain standard that applies to consideration of race, color, national origin, whether it's for a purportedly benign reason or for a bad reason. So I think you work with the legal standard that you have, and if in a particular case you see that this kid really needs to have a placement that takes into account whatever his race or ethnicity may be, I think that the law does permit that to happen. So it's not a perfect fit, but hopefully we'll get better as we do this more.
So I'm from Anyway, I'm from California, and as most people know, California is a very diverse melting pot of ethnicities. And I just recently came back to the field of social services after 12 years, and I left actually around the time when Mepa was being implemented. And I'm back now, and I'm learning more about it. It seems very severe to me as far as coming back into the field of social services and trying to implement Mepa and dealing with the ethnicities that we serve in California and being responsible for the counties to also be in compliance with Mepa as well is overwhelming to me. And when I was looking at the examples of what we're supposed to do and not do, to me, some of it seemed that we should be doing the opposite. And especially after hearing the presentation this morning, I thought what we learned about this morning negated what we just learned about now. And so I'm just, in the part about the preparing and the assessment as a licensed clinical social worker, I think the two go together, that we need to not only assess at the same time that we're preparing, so I don't see how they can be mutually exclusive. So I just wanted to make those comments, and that's what I have to say.
I'm Judy McKenzie, and I'm an executive consultant with Adopt Us Kids, and we do a lot of work with states. And my question is, what is permissible, or how can states measure their compliance with the diligent recruitment provisions of the law? For example, can they use the race of parents to look at the ratio of children to parents by race, to measure not only their current state, but their progress in complying with the diligent recruitment? I think there's a lot of emphasis on the placement provisions of MEPA, but not enough emphasis on the diligent recruitment. And I would like to hear more about what is expected of states in terms of diligent recruitment and how they can look at whether they're making progress. Thank you.
We don't have anything that specific in our guidance, so we'll take that question back and answer it afterwards. Thank you for asking it.
Anybody else? All right. Well, we appreciate, the states have been asking for information on this. We really appreciate you coming and talking, because I think our best weapon is information. And so it's really helpful to hear from you, and also helpful to have your comments and your thoughts. We really do appreciate that. And now I think it's time to eat. So if we could all move into the luncheon, and we're going to have luncheon and then have our ceremony a little bit after that. Thank you.